Hello. Welcome to Mentoring with the Masters. My name is Jennifer Kuyrkendall. I'm the Third Circuit representative for the Young Lawyers Division Board of Governors. Today I have the pleasure of speaking to Bruce Robinson of Robinson, Kennon Kendron in Lake City, Florida. Bruce is a board-certified civil trial lawyer and has been since 1983. Today, Bruce is going to be speaking with us about interrogatories. Bruce, welcome.
Well, thank you. I'd like to first mention the rules that you have to deal with, which are Rule 1.280 and 1.340. Now, interrogatories are one of our most common and most economical forms of discovery. I would suggest that you read the rule, though, and read it regularly, not just every year or something. We are limited to 30 interrogatories under the state rule. The federal rule is somewhat different. I'm not going to go into the federal rule here for this purpose. But know that you're limited to 30, and if you use interrogatories in an area where the Supreme Court has adopted forms, you are required to use their forms. Now, you don't have to use all of them, and I frequently don't, and you can add to them as long as you don't go over 30. After you get over 30, you have to have leave of court. Now, it's important to understand that when you ask these questions, it's not objectionable, for example, that you ask an interrogatory that calls for some conclusion about fact or even opinion. However, the answer you give to that, if it's qualified, it can't be used to impeach you unless otherwise admissible. It's also important to know that when you use, and you can use an interrogatory answer at trial if it's otherwise admissible, but the other party can then require that you use any other answer to that interrogatory, set of interrogatories that he thinks in fairness, and the court agrees, should be heard. Now, one of the areas is experts. You can find out with interrogatories who the names of the experts are, generally the subject matters and the basis for their opinions, and generally the scope of their opinions in interrogatories. You are limited, though, to the areas they say. For a while there, we had the big debate about how much we could find out about their income and things of that nature. Read the rules, read the cases on that. Now, if you object to an interrogatory on the grounds that it's burdensome or oppressive, it's unduly burdensome, it's expensive, and the other side move, you better be prepared to have an evidentiary basis, not just say it is. Because there are cases out there that say you must make an evidentiary showing that it is unduly burdensome or expensive to you. And a lot of people get caught on that because they don't realize that. Now, you also in interrogatories have the option to say, we will produce the records, but you must identify the records, where they are, and the person or persons whom will be available to help you glean the answers from these business records. Also, if it's electronic, as so much is today, you must provide it, if you're going to rely on this as an answer to an interrogatory, in a form reasonably usable by parties. And sometimes when you have a lot of records and you don't want to search them, you can use this option. However, know that the other party, if he's thorough, is going to fly-spec your records very carefully. Also understand that if you answer interrogatories as a party in a lawsuit, your answers aren't binding on a co-party. They are binding on you, though. The rule also says, and this is commonly violated, most lawyers don't object to it, but once in a while one does, you are supposed to provide a blank space, and the answer is supposed to be in that blank space following the question. Very frequently, though, lawyers today, because the information is so great, will just attach the answers on separate sheet. Rarely do we see an objection, but once in a while you do. And the rule is clear, though, that you have to, not you have to, but you are supposed to put the answers following the question. I find that's frequently violated, though. Now, when you file them, of course, you need to serve your answers on all parties. But again, remember, the rule says unless the court needs to review these in some hearing or trial, you don't file them. You don't file everything anymore. Once upon a time we did. We filed everything. Now, if you as the requesting or interrogating party, I guess, since you're sending interrogatories out, if you receive an objection, it's incumbent on you to seek the hearing, to have the court rule on the objection. If not, it'll just sit there as objected to. And those are a few little tips that I think are helpful with interrogatories.
Well, Bruce, I certainly appreciate you providing all of that very useful information. A good takeaway, start with the rule. That's with anything, not just with interrogatories. So again, on behalf of the YLD, I do appreciate you being here and sharing parts of your 43-year career wisdom with us here today. Thank you for being here.
And I enjoyed being here. Thank you.
Absolutely. Thank you.